All right. Hello, everybody. Hello. Welcome. What a great crowd. I'm Michael Scharf. I'm the co-dean of the law school. This is Avi Cover, professor who is our director of our Institute for Global Security Law and Policy. And on behalf of the law school, we are very happy to welcome you to today's event. If you don't have a seat, there are a couple more up here. And we're pretty much filled, which is fantastic. And you're in for a real treat today. The topic of the United States and Guantanamo Bay has been one that this law school has been involved in for quite some time. So right after 9/11, when the Guantanamo Bay military commissions were created, I was asked to testify before Congress about the reform of the commissions. We have had several conferences on the topic of administrative detention, on closing Guantanamo, on torture and the war on terrorism. So this has been a topic that we have published and brought experts from all over the world on. We've had two of the chief prosecutors of the Guantanamo Bay military commissions here, Mark Martins and Mo Davis, and we have 5 of our alums who have been involved as prosecutors and defense counsel at Guantanamo Bay. So this is really an important subject, not only to the United States, but to this law school, and we're very glad to see all of you here today to share our discussion of it. Let me turn it over to Professor Cover.
Welcome. I have the distinct pleasure of introducing the speaker who will introduce the speaker, having been introduced by Dean Scharf. I'll just say that we really are thrilled to have Brigadier General Baker here. It's a real pleasure for all of us to learn about this interesting legal system that has been going on for now 17 years. So some of you were in kindergarten, I imagine, when these military commissions were created and put into effect, and they are still persisting. For better or for worse, depending on your perspective. But our guest speaker introducer is the federal defender here in the Northern District of Ohio, Steve Newman. Happily, a lot of times you get, kind of some very dry biographical information to be provided. And I could tell you all about all of Steve's credentials, but I think more important, a couple of obviously very distinguished things that I do want to share, but then I'll give you the real key elements about Steve. Served in the military for quite a bit of time, enlisted in the Marine Corps in 1983. His active duty highlights included service as line defense counsel representing Marines and sailors accused of crimes, service as the senior defense counsel at Camp Lejeune, followed by service as regional defense counsel in the Eastern region, which included, at that time, everything, in his words, east of the Mississippi and Iraq. And finally, retired from the Marine Corps as chief defense counsel of the Marine Corps. But perhaps what you'll really be interested in getting to know Steve later is to hear his lovely singing voice and maybe take a look at some of his fantastic penmanship. But I will now turn it over to Steve Newman.
So by way of explanation, when people ask me for bullets on my bio, I typically say, I have a lovely singing voice and fantastic penmanship, and leave it at that. But in this particular instance, I did provide a little bit more background. And it is my distinct pleasure today to introduce my very good friend, Brigadier General John Baker, U.S. Marine Corps. He's asked me to keep my remarks brief, and while he still remains senior to me, and while I yet remain subject to the UCMJ because I am receiving retired pay, I am going to take liberties and do as I see fit. So you can feel free to charge me, and I will gladly accept that court-martial. General Baker and I have known each other for several years. In fact, I might say that some of his best ideas were actually mine. But as a retort, he would clearly say that that is the reverse. In fact, we've joked over the years about how we've stolen each other's intellectual property from time to time. But in actual fact, there's no doubt in my mind that I have benefited from this exchange significantly more than General Baker has. As emblematic of that fact, you heard that I retired as Chief Defense Counsel of the Marine Corps. That job led me to the job that I have now, and I would not have had that job but for the recommendation of General Baker. But more broadly, for over 20 years, General Baker has been one of the most significant contributors to the military justice community in our generation. And I don't say that by way of hyperbole. There are substantive facts that demonstrate this to be the case. His contributions to military legal justice are incomparable. As Chief Defense Counsel of the Military Commissions Organization, his example of courageous, principled leadership has served as an inspiration to me, has, I think, inspired legal professionals, both civilian and military, across the country. It's a reminder of why we all went to law school in the first place. To stand on our constitutional principles and to speak truth to power. As Deputy Director at Judge Advocate Division, the organization which manages lawyers in the Marine Corps, he oversaw what was a systemic change to the structure and organization of legal services in the Marine Corps and the legal services worldwide, making it more fair, making resources more available to defense, and making it more accessible to the individual Marine. As Chief Defense Counsel of the Marine Corps, he accomplished something that Congress demanded of the Marine Corps more than 30 years ago, and which each of his predecessors as Chief Defense Counsel of the Marine Corps had tried to accomplish since that time: a truly independent defense organization within the Marine Corps, free of command influence and prosecutorial whimsy. It's what we now know today as the Marine Corps Defense Services Organization. But beyond that, he's held every potential job you can hold as a military justice professional. He's been a trial counsel prosecutor, he's been a defense counsel, he's been a military judge, he's been a staff legal advisor, he's run law centers. And as an individual who has personally fallen in on two organizations that General Baker ran, I can tell you that he is a phenomenal leader. His Marines love him, and he loves his Marines. But beyond that, it's my experience that there are two types of general officers in DoD. There are those who are very interested in being a general officer and typically succeed in protecting the institution and their organization. And then there are those who are interested in succeeding as a general officer. The former, as I said, are typically good stewards of their organization. The latter have strategic vision. They're risk takers, they're visionaries, they're agents for change, not just caretakers. In terms of the parable, it's the difference between the servant who, with wisdom and forethought, risks his master's money in return for threefold, versus the servant who simply buries it in the ground. General Baker is that visionary strategic leader. I've served with general and flag officers from all services. I've known and seen a variety of leaders in DoD, but I expect by the time this talk is over, you will agree with me that there are none who have more courage, there are none who understand principled leadership better, and there are none with greater strategic vision than my friend, General John Baker. Ladies and gentlemen, General Baker.
Okay, so before I start, there are like 8 seats here. If someone wants to come and sit down, and there's a couple more seats up here. Well, Steve, thank you, and frankly, thank everybody for the introduction. It's really a pleasure to be here. It's my first time in Cleveland. I've even made it to the Rock and Roll Hall of Fame earlier today, and it's an honor to go out in different places and talk about, really to talk about the work that the people that work for me do. We're going to spend some time today talking about national security. And if there's one thing that Guantanamo can teach us, and I hope that I make clear today, it's that protecting the rule of law in the 21st century warfare and in national security requires a big picture view of our national security policy and how it actually plays out on the ground. I'm about to start on a group, I'm going to use a set of prepared remarks that have been reviewed by a security professional so that I don't delve into any classified information. But before I go into that, really thank you for all of you for attending. I was wondering if there were going to be anybody at this talk, and the room is full, and I am honored by that. But the amount of people that are going to listen to me talk about the military commissions today is, like 27-fold the amount of people that pay attention to what's going on down at Guantanamo. A year ago, there was a hearing in a case by the name of El-Nashiri. It's a capital commission involving the USS Cole, in which I was held in contempt of court. And I'll talk a little tiny bit about that. But there was a single reporter there, one reporter. There were 3 court observers. So in a pretty significant first time an American citizen had been placed in detention at Guantanamo, there were 4 people there that weren't involved in the court proceeding themselves. So I'm really happy that there's a bunch of people that are here that are going to learn more about Guantanamo. So you've heard from, in the past, Case Western has invited a couple of the chief prosecutors. Today you're going to get the view from the other side. And I'll tell you right now, I'm not going to pull any punches. I'm going to give you my view of what the good and the bad of the military commissions. And you can take from my talk from what you want. There are, Case Western has sent 7 people that serve at the military commissions. It's pretty impressive. There have been just untold numbers of military members that go down to Guantanamo serving in the military commissions as prosecutors, defense counsel, supporting the judges, serving as judges, and it's really a constant turnover of people. All right, I'm going to now turn to my prepared remarks. All right, so to introduce you to the Alice in Wonderland through the looking glass world of the Guantanamo Bay military commissions, again, I'm going to use remarks that have been vetted by a security professional. My apologies for reading from prepared remarks. When I speak in public, I actually am a outline bullet point sort of person, but when I talk about the Guantanamo Bay military commissions, I read from a prepared script. And a huge reason why I read from a prepared script is because of the security rules, and I'll talk a little bit more about the security rules. I also want to apologize for those of you that have either read something that I've written recently or have watched a speech that I've made on the internet, because a lot of what I'm going to talk about I've said before. I kind of continually update this talk. It really kind of focus on what's going on. I want to be clear that the views that I'm about to express are mine, and they're my views alone. They certainly do not reflect the views of the Department of Defense, the United States government, or any agency or instrumentality thereof. Nor do my views represent the views of any individual defense team. As the Chief Defense Counsel, I supervise the organization, but each individual defense team represents their client, and they speak on behalf of their client. So first, let me give you a brief introduction. As you heard from Steve Newman, I'm a career Marine. After I started out as a logistician, the Marine Corps sent me to law school, and since then my legal career has been primarily in the military justice system. And I've had pretty significant experiences in 3 significant seats in any courtroom. I've been a defense counsel, I've been a prosecutor, and I've been a judge. But before my current assignment, I could not conceive of some of the extraordinary things that are so perilous to a fair trial that I've seen unfold down at the military commissions at Guantanamo Bay. Since 2015, I've been the Chief Defense Counsel, and I am really privileged to head the organization called the Military Commissions Defense Organization, or the MCDO as we call it. The MCDO's mission is to, quote, provide ethical, zealous, independent, client-based defense services under the Military Commissions Act in order to defend the rule of law and to maintain public confidence in the nation's commitment to equal justice under the law. Put into one sentence, the MCDO defends the rule of law from a military commissions apparatus that is a failed experiment. It is a system that is flawed in both design and in execution. I am frequently asked why the trials at Guantanamo Bay are taking so long. I mean, it's 2018. And for those of you who have heard me, for those of you that have followed the commissions in the paper, you know that there is no trial date set for any of the men who are currently detained at Guantanamo. Today, this week, or this month, we just passed the 18th anniversary of the USS Cole bombing. We just passed the 17th anniversary last month of 9/11, and there are no trial dates set for any of the cases currently on the docket at Guantanamo Bay. Both of the judges who are hearing the capital military commissions cases just retired. And the judge who's presiding over another case, the Hadi al-Iraqi case, was reassigned, meaning that the prosecution of all contested commissions cases at Guantanamo Bay, including the 9/11 and the USS Cole capital cases, have to start over with new trial judges. For many, the delay in getting these cases to a fair resolution remains their biggest concern about the military commissions. But this delay is the byproduct of problems that are more fundamental, with the potential to reach far beyond these cases, both as precedent and by corrupting our core principles. The issues in our cases, particularly the effects of torture, would cripple any normal court case. And they are layered on top of the mayhem embedded in this failed experiment that we call the Guantanamo Military Commissions. To illustrate what I mean, I'm going to discuss some of the major issues currently facing the McDow defense teams. These issues demonstrate at varying levels why the Guantanamo Military Commissions are a national disgrace. And not coincidentally, these same events shine a light on what is lost and what we are left with when we take actions in the name of national security that degrade and erode the rule of law. First, the military commissions operate with a level of secrecy that has to be seen to be believed. The government seems to regularly use classification to conceal information that it finds embarrassing. It also regularly refuses to produce relevant documents by claiming a, quote, national security privilege, although the prosecution can't explain how information published in newspapers or in foreign courts is being protected by hiding it from defense attorneys with security clearances. For example, during a recent hearing in the 9/11 case that I attended at Guantanamo, the military judge asked the Defense Counsel where he'd gotten a piece of information that the government had previously withheld, claiming the information was so important to national security that it could not be provided to defense teams in capital cases. The Defense Counsel explained that the government had provided the same information to BuzzFeed in a FOIA response. And even though the government had refused to provide it to him in a capital case, he was able to pull the same information off BuzzFeed's website. When a clearly frustrated judge asked the prosecutor to explain what could possibly justify hiding facts from a defense team in a capital case, but then provide these same facts to a reporter a year later, the prosecutor tap danced around the question. Just like they did when the same defense team caught the CIA providing details concerning their client's torture to the makers of the film Zero Dark 30, yet the government refused to provide this same information to his attorneys. Unsurprisingly, the government's demand for secrecy, particularly about the details and effects of torture, also creates unimaginable roadblocks for defense investigations. When I came to the McDow 3 years ago, I did not foresee being in a situation in which the chief prosecutor would explicitly threaten my defense counsel with the possibility of criminal prosecution if they continued to conduct independent investigations of their client's torture overseas. But that is in fact what happened in January of this year. And when the defense teams protested and told the judge that these are capital cases and that we need to do an investigation, the prosecution told the judge that the defense in a capital case had, quote, no right to investigate. Keep in mind that according to the Senate torture report, the events the defense are trying to investigate happened a decade and a half ago, and that these defense counsel have the same security clearances as the prosecutors. But despite these clearances, despite these being capital cases, and despite the fact that what they are trying to investigate is their own client's time in pretrial custody, somebody has determined that these defense counsel do not, quote, need to know the information. There finally appears to be some consequences for keeping this information from defense counsel who have appropriate security clearances. You heard me talk earlier that the judge on the 9/11 case recently retired. The last thing the judge did in that case before retiring was to find that while the government could still continue to withhold details of detainee torture, that this withholding of this information affected the defense counsel's ability to present substantially the same defense as they would if they had access to these details. So the judge issued a ruling barring the government from using these so-called clean team statements that were taken by the FBI in 2007. These statements were taken after the McDougall clients had been tortured by the CIA and transferred to Guantanamo. And he based that decision on the fact that the defense could not adequately challenge the admissibility of those statements, because they couldn't know exactly how the CIA had tortured confessions out of their clients in the years before the FBI was sent in to bat cleanup. In other words, because the defense isn't able to fully investigate their clients' torture, the judge decided to ban their inculpatory statements altogether. The government has asked for reconsideration of that ruling and has threatened to appeal if they don't get their way, because according to the government, the clean team statements are their best evidence. So the United States government in 2018, 17 years after 9/11, is explicitly staking the prosecution of the 9/11 cases on statements that a judge has already ruled are too questionable to admit because the specter of torture looms too large over them. All of this because of the government's insistence of keeping vital information from cleared members of the defense team who have the same clearances as the prosecutors. To understand the government's zeal for secrecy, you must understand what the government is trying to hide. Each time new information about the CIA torture becomes public, people recoil and say that this must be the worst that's happened. Yet each new revelation has managed to outstrip the horror of the previous one. You've probably heard stories of criminal defendants who have suffered terrible abuse, but rarely has that abuse been by the very people who are still detaining them, who are pursuing their prosecution, and who are seeking to execute them. You probably believe that you may know in a general way about the events of the CIA program, given their coverage in the press. But did you know that the CIA regularly threatened detainees' families, including threats to kill children? While you probably know that Khalid Sheikh Mohammed, the alleged mastermind behind the 9/11 attacks, was subjected to waterboarding, did you know that he and others were also subjected to a form of anal rape, euphemistically called, quote, rectal rehydration? While you probably know that detainees were deprived of sleep for days at a time, forced to stand with arms shackled overhead, naked in cold rooms with blinding lights and deafening sounds, did you know that some were forced to urinate and defecate on themselves, and that the CIA had a policy allowing them to be left in their own filth until, quote, evidence of loss of skin integrity due to contact with human waste materials, unquote, or to be more precise, until they developed open sores? While you probably have heard claims that our government only used torture for intelligence purposes, did you know that earlier this year the government finally declassified their objective for torturing Ammar al-Baluchi? They tortured Ammar al-Baluchi as a form of human experimentation, using him as a test subject to train new interrogators. While you probably know that Abu Zubaydah was interrogated while severely wounded, did you know that he was repeatedly waterboarded, slammed against a wall, and forced to stand, sit, or crouch inside wooded boxes with such violence that his bandages, quote, came completely off? And did you know that 3 days later, the guards, quote, swapped out subject's wrist shackles for a clean pair since they occasionally came into contact with the exposed wound, end quote. And then his captors would, quote, demanded that the subject cleaned his wounds as they had no interest in getting exudate from his wound or any of his bodily fluids on or near them. While you probably know that Majid Khan, a lawful U.S. resident, grew up in suburban Baltimore, did you know that when Mr. Khan refused to eat, detention personnel inserted a tube into his rectum, pumped it with 2 bottles of Ensure, and a, quote, lunch tray, which consisted of pureed hummus, pasta with sauce, nuts, and raisins. According to CIA records, he was, quote, very hostile to rectal feeding and removed the rectal tubes as soon as he was allowed to. Let me point out that this describes a man forced to participate in his own torture. On 2 occasions, Majid Khan attempted to cut his wrists. He tried to chew his arm at the inner elbow. He tried to cut a vein on the top of his foot, and he tried to cut into his skin at the elbow joint using a filed toothbrush. Other detainees also attempted acts of self-harm or asked to be killed or allowed to die. Even with these additional details, you do not know the worst that has happened. Let me state that in another way. The worst is still hidden. Defense Counsel know more than the public, but they don't know the worst either. They should, and so should the juries, especially in capital trials. As the McDough Defense Counsel argued when challenging the government's torture hiding discovery practices, he, quote, needs the gritty, granular detail of what U.S. agents did to his client. His jury needs to smell the urine, the feces, the blood, the sweat, and see just how vile and disgusting this process was. Then, if convicted, defense counsels can ask the jury, do you have to kill him now? This torture, and let's call it that, this torture was not perpetrated by rogue elements. These monstrous acts were systemically instituted, embraced, and promoted at the highest levels of the United States government. This same government that is fighting tooth and nail to hide information about these acts, all in the name of national security. It apparently has not occurred to the deciders that by attempting to evade accountability for these acts of torture it perpetrated, it might itself be harming national security, to say nothing of America's position as a steadfaster defender of the rule of law. Although the 9/11 judge's decision to ban the, quote, clean team statements went against the government, finally imposing some consequences for their lack of transparency, the military commissions at Guantanamo remain vulnerable to outside pressures seeking to influence the process against the defense. I'm sure you can imagine the importance of preserving independence from political considerations in national security cases. But consider what began happening in early February of this year. That's when the, quote, convening authority was fired along with its chief legal and policy advisor. The convening authority is the DoD civilian who oversees the military commissions and is responsible for, among other things, negotiating plea deals like a district attorney does in most counties, and also making funding decisions on defense expert requests like many district court judges do in federal cases. A few months ago, pursuant to an order from a judge in Guantanamo, Secretary Mattis and his staff submitted an 11-page declaration attempting to justify the decision of firing the convening authority. But the former convening authority provided a different declaration explaining that he had no idea why he had been suddenly removed, that he'd not been approached or warned about poor performance prior to being fired, and that he was forced to conclude that his firing had something to do with the decisions that he made as the convening authority. The why of this firing could affect the legitimacy of these cases because of a military concept called unlawful influence that is prohibited under the Military Commissions Act. So if Secretary Mattis was influenced by his staff or others to fire the convening authority because of how he was overseeing these cases, or because, as we now know, that the former convening authority was meeting with defense counsel to discuss potential plea agreements, that might discussing potential plea agreements that might preclude the death penalty in the 9/11 cases, that could be a huge legal problem. Since these declarations were filed, we have learned many more disturbing details. We have learned, for an example, that according to a sworn declaration, that the chief prosecutor was not getting along with the convening authority, and according to this declaration, behaved, quote, inappropriately toward him. And we have learned that 2 days before the first memo was written addressing the potential firing of the convening authority, the convening authority had circulated a proposal to take some authority away from the Office of the Prosecution and to consider non-death plea agreements in the Guantanamo cases. We'll learn in the next few months whether the new judge in the 9/11 case agrees that this raises the specter of improper influence on the convening authority. But the pressure on the military commission system doesn't just come from within the Department of Defense. While they're investigating whether the convening authority had been unlawfully influenced, McDough Defense Counsel learned that Attorney General Sessions had called Secretary Mattis to complain about the potential plea deal. Rather than contest this, one of the prosecutors in Guantanamo excused it to the judge by saying it only made sense for the Department of Defense to try to influence the outcome, it only made sense for the Department of Justice to influence the outcome of a Department of Defense prosecution. Because if the 9/11 defendants were offered a plea deal, that might make it harder for federal prosecutors to get death sentences against defendants in U.S. federal courts. Or take what happened in U.S. v. al-Nashiri. After 3 civilian lawyers withdrew from the case for ethical reasons because they had found a hidden microphone in their attorney-client meeting room, which I'll get to later, the judge began attacking them personally as well as the McDough as a whole, calling them, quote, unprofessional and, quote, lawless people acting in defiance of the rules. But as the Supreme Court has said for decades now, the system that appoints criminal defense attorneys is obligated to respect the professional independence and the professional judgment of those attorneys. Writing in Polk County v. Dodson, the Supreme Court explained that, quote, a defense lawyer best serves the public not by acting on the state's behalf or in concert with it, but rather by advancing the undivided interests of the client. Pay attention to that language. A lawyer best serves the American public when she is able to make a full-throated defense of her client. That's a concept so important to the rule of law that Chief Justice Roberts commissioned a report, which was just released this fall, proposing a complete restructuring of the federal public defender system so as to preserve their independence. But it's a concept that doesn't seem to carry as much weight down at Gitmo. If you're paying attention, there are signals everywhere about the government's expectations for situations akin to the Guantanamo military commissions. It's not that far of a stretch to go from, as National Security Advisor John Bolton said recently, quote, we will punish anyone who investigates potential war crimes in Afghanistan, to, quote, we will punish anyone who investigates acts of torture in CIA black sites. And it's fair to say that a government that is willing to prosecute those who assist the International Criminal Court in investigating alleged American war crimes might also be willing to prosecute those who assist in defending alleged terrorists. Indeed, as I told you earlier, the chief prosecutor has threatened to do just that to the 9/11 defense teams. The National Security Advisor's recent speech about the ICC leads me to the last point that I want to make. That the justice we say as a country is good enough for detainees in Gitmo, the justice that we claim is vital to our national security, is explicitly and exactly the kind of injustice that we loudly reject when the defendants are American citizens. According to the National Security Advisor, the U.S. government is very concerned about the prosecution of U.S. citizens in courts that lack checks and balances or claim jurisdictions over crimes that have disputed and ambiguous definitions, or that purport to have automatic jurisdiction, meaning that it can prosecute individuals that have no connection to the court or the government that ratified that court's existence. A court lacks legitimacy, Mr. Bolton implied, if it can just grab whoever it wants and prosecute those for things the courts claim they did in foreign countries, without the consent of nation states or the individuals who it purports to exercise jurisdiction. I am not an expert on the ICC, and I don't know enough about the procedures to opine on whether Mr. Bolton's descriptions of the rules are correct. But it's not hard to see the parallels between what Mr. Bolton is claiming to condemn about the ICC and what is happening in Guantanamo. We've already seen that the commissions are subject to pressure from the executive branch that owns them. And we know that right now, the higher appellate court that is supposed to oversee the military commissions, the Court of Military Commissions Review, doesn't exist for the 9/11 cases because so many of the Court of Military Commission Review judges have conflicts that the court is currently, quote, inquirate, meaning that it doesn't have enough non-conflicted judges to decide any issues pertaining to the 9/11 prosecution. So we're not sure at this point who's going to provide those checks and balances. Or think about the fact that all of the men currently being prosecuted in war crimes tribunals in Guantanamo are charged with conspiracy, which is an American domestic crime that has never been recognized as a war crime or a violation of international law. Or consider the military prosecution of Mr. El-Nashiri and Mr. El-Darby for the bombing of the MV Limburg, a French ship chartered to a Malaysian company which was carrying Iranian oil in Yemeni waters, in which a Bulgarian sailor was killed. Somehow, the U.S. government has found a way to assert jurisdiction over that crime in an American military court, without there being any concurrent domestic prosecution in France or Bulgaria, and certainly without the consent of either Mr. El-Nashiri or Mr. El-Darby. The inescapable conclusion is that the reality of the military commissions is worse than Mr. Bolton's criticism about the ICC. The justice America is willing to give the Gitmo detainees doesn't come close to the justice it demands for its own citizens. It's second-class justice, the obvious result of an experimental system that has completely failed in both design and execution. Let's take one last example of that second-class justice. And it's a situation that I have discussed at length in many other speeches over the last several years. And that is a constant government intrusion into the attorney-client relationship at Gitmo. I won't get into the history of those intrusions today. Instead, I'll pick up from this last March, when the government admitted publicly that there were hidden microphones in the location where at least Mr. El-Nashiri, the accused in the USS Cole case, met with his lawyers. The government attempted to minimize these microphones by calling them, quote, legacy microphones. The El-Nashiri team discovered one of them in August of last year, but they were told that the existence of the hidden microphone was classified. They asked for discovery about the microphone, but that was denied. They asked to have a hearing about the issue, and that too was denied, because the prosecution had promised that they, the members of the prosecution, had not personally listened in on any of Mr. El-Nashiri's attorney-client meetings. And remember, attorneys can't tell Gitmo defendants classified information, but the members of the El-Nashiri defense team tried. They asked the judge for special permission to simply inform their client about the risks that they had discovered, but that too was denied. That meant they couldn't tell Mr. El-Nashiri that somebody had potentially bugged the room where he'd been meeting with his lawyers. You don't even have to really think about whether this is something that we'd allow in American court, with American defense lawyers and American citizens as defendants. You only need to look to Kansas, where a federal prosecutor was put out of a job after the government taped and in some cases listened to hundreds of conversations between defense attorneys and their clients. Now consider what happened next in Mr. El-Nashiri's case. After they found the microphone, 3 of his counsel requested my permission to withdraw from that case due to the ethical situation in which they found themselves. One of these lawyers was Mr. El-Nashiri's learned counsel, the expert in death penalty defense that he is entitled to by law. After some significant deliberation, I found that each had provided good cause to be excused, and I granted that permission to withdraw. It may seem strange from a civilian perspective, but the way that I read the governing rules and the military commissions, which are issued by the Secretary of Defense, is that they mean what they say and how they are written. And that gives me, the Chief Defense Counsel, that responsibility. However, this provoked the military judge on the El-Nashiri case, the same one who had denied them discovery, the same one who had denied them a hearing, and the same one who denied their request to simply inform Mr. El-Nashiri about what they had found. And he ordered me to rescind my excusal. And when I declined that order as unlawful, he, incredibly, held me in contempt in violation of the Military Commissions Act and in violation of over 150 years of military case law. And he gave me a 21-day sentence of confinement. I challenged my obviously unlawful contempt conviction, and a few months ago, a federal judge, as expected, ruled that the military judge had acted unlawfully and beyond his authority, and he overturned that conviction. This is not quite what happened, but try this as an analogy. Imagine a big law firm working on a criminal case pro bono. Now imagine one of the associates on the case left the firm for personal reasons. Imagine the judge ordering the managing partner of the firm into court and demanding that he testify about the circumstances behind the associate's decision to leave, and then demanding that he force the associate back to work. Now imagine that the judge jails the partner. Is that a system that we would tolerate for Americans? And it got worse, because down at Guantanamo, the military judge went ahead with the Nashiri hearings in the case during 3 different months. Hearings at which the government introduced evidence into the record, despite no jury having been selected yet, all while Mr. El-Nashiri did not have a lawyer with him who'd ever tried a murder case, much less a death penalty case. Last week, our immediate appellate court, ignoring classified information that I am prohibited from discussing, issued a ruling that essentially said that a Guantanamo Defense Counsel must ignore things like hidden microphones found in attorney-client meeting rooms, provided that a government actor says that there is, quote, nothing to see here. The kicker to all of this is that the El-Nashiri team only found 1 microphone. But the government's later statements about the matter admitted that more than 1 microphone was removed from the meeting location. And I invite you again, one last time, to imagine an American court in which multiple microphones are discovered in the defense attorney-client meeting room, and the only consequences are that somebody on the defense side is sent to jail. How everything I talked about this afternoon ultimately gets resolved, I honestly don't know. Nor, if I am being honest, am I exactly sure why national security requires that we set up an ad hoc court exclusively for aliens on an offshore naval base in which defense attorneys cannot investigate and have to live with the fear of having their law licenses threatened because they object to microphones in their meeting spaces. But what I do know is that what happens at Guantanamo matters. After the passage of the Military Commissions Act, a former chief prosecutor for the military commissions, I believe it was Mo Davis who has spoken here before, stated that his goal for the Guantanamo military commissions was to be remembered in the same favorable light as the Nuremberg trials. The United States government, unfortunately, has failed and continues to fail this test. Future generations will look back at these proceedings as a missed opportunity for America to show the world its commitment to justice, its commitment to human rights, and its commitment to the rule of law. If the U.S. government still intends to use Nuremberg as its guide, they would be wise to learn from the chief prosecutor at Nuremberg, Justice Robert Jackson. One political theorist wrote of Justice Jackson that his Nuremberg trials revealed the rule of law in Germany as a moral goal, not simply a political tool. Justice Jackson also recognized the danger of political trials, which, quote, mean committing the judiciary to the politics of the remote future and of persecution. And it was Justice Jackson who recognized the danger of powerful nations unilaterally dispensing justice onto a purported enemy. He said in his opening argument at Nuremberg, quote, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well." Sadly, instead of respecting the Constitution and ensuring equal protection under the law, the U.S. government is choosing to drink from a poisoned chalice at Guantanamo Bay. That's the end of my prepared remarks. I appreciate your attention. I will take virtually any question unless it involves classified information or privileged information. But if anybody has any questions?
General, I don't know if you realize this, but if you look at your shoulder, it's Robert Jackson's portrait.
Oh, I did not. I didn't set that up. Yes, sir.
A very well stated introduction. It was mentioned that you were instrumental in helping to develop the Independent Criminal Defense Attorneys Association within the military, and as a result, we can rest assured that defense attorneys in the military are independent, free I was curious if you have that same confidence in the military judges, that they are equally free from influence from the Department of Defense and others.
It depends. It depends on the system. So I am confident in the military justice system that our judges are free from influence. I mean, there's an expectation that if you go to become a judge, that you're going to go and do what you think that is right. In the military commission system, right before I became the Chief Defense Counsel, in the winter of beginning of 2015, a series of military judges found that the government had in fact attempted to influence them. And the way that they had attempted to influence them was they were going to, their plan was to order all the military judges to go to Guantanamo and live. And then that would speed up the process with which they tried their cases. So the judges did find unlawful influence and put some protective measures in place. We have all new judges, and I know a couple of them personally. I certainly hope that they'll be free from influence. But the amount of pressure that is put on the individuals that are involved in the military commissions process is really uncomparable to what it is in the military justice system. I don't know if that answered your question or didn't answer your question. Yes, sir.
Thank you for talking. I'm mortified that I didn't know what you were saying here today. I consider myself a fairly intelligent American citizen. What can we do to help you in your job?
But I think that the question, if you didn't hear, was what can people do about what's going on down at Guantanamo? Number one is pay attention. Speak to your representatives, pay attention. I mean, but where I really struggle is how do we fix this? And that's really honestly, people have often asked me, is the problem the rules? Are the rules bad? And we don't really. These rules have not been tested in a system that is free from torture, because torture really has infected everything. I don't know how we get out of where we're at. I mean, I honestly don't. A big problem with the 9/11 and the USS Cole cases is they're capital cases. And the United States has a level of due process that we give capital cases. And the level of due process that the American government, or that the American kind of system of justice has established for capital cases, the commission system will never, ever, ever meet. So I don't know. That's not a very good answer, but I don't know what you do, except for attend things like this, think good thoughts for us. I wish I had a better answer for you, but I don't.
I'm wondering that I feel like I may know the answer, but the judicial order that you mentioned that excludes the statements of detainees made during torture, is that classified? Is that something that we can only access?
Parts of the judicial order are classified. So what Judge Pohl in the 9/11 cases did is, let me give you probably a longer answer than you asked for. So in the commission process, the prosecution gives, much like in federal court, will go through a process of, they get some classified information that they don't want to give to the defense. And they do summaries and substitutions of it. And so for the last 6 years, Judge Pohl has reviewed all these summaries and substitutions, and it's concluded that the defense just can't be in the same spot because of the summaries and substitutions. So his order is unclassified. But really what his order is based on is 6 years worth of classified information. And that's what makes this new judge's job even, starting a new case is hard to begin with. one of the first orders of business he has to do is decide the government's request for reconsideration. So he's got to go read 6 years' worth of stuff. Does that answer your question?
Yes, thank you.
Yes, sir.
Yes, how were these acts that you described against these prisoners found out, and were there any rules on the interrogation that the CIA or whoever the questioners or interrogators had, and was there any supervision as to the interrogations that took place?
So how these acts were found out, I mean, how we know about them, because for several years of the military commission process, the defense request for this information was denied. But the Senate subcommittee, the Senate Select Subcommittee on Intelligence did a report. And they reviewed, part of their intelligence oversight, the CIA gave them access to a whole bunch of their records. And so there was an evolving, so to answer your questions, the way that we found out it was because of the Senate's work.
Because of what?
Because of the Senate subcommittee, Senate Select Subcommittee on Intelligence work. That's mostly where we got that information. Once the SSCI stuff was done, the government then also provided some additional discovery. What were the rules? The rules evolved, frankly, the rules evolved from 2001 forward. There's a lot of debate about what acts were the acts that were done with essentially permission of their superiors, or were there rogue interrogators? I think there's probably a little bit of both. But I don't know, frankly, enough granular detail to give you a good answer as to what the specific rules were. I do know that one of the things that President Obama did pretty early in his administration was make a decision that we are going to, quote, look forward, and how we're going to change and fix interrogation techniques and not look past on what was done in the past. And did that come close to answering your question?
Yeah, just on the supervision, though. Who supervised the interrogators to make sure that they stayed within these vague rules that you just mentioned?
Yeah, I don't have a good enough answer. I can't answer that question. Sorry.
How has the whole scenario down in Guantanamo been affected by the political landscape? Specifically, was there any change between Bush and Obama, and then Obama and Trump?
There was the short answer is yes. There was a change. There was a change from Bush to Obama, and then there was a change from Obama to Trump. I can talk more specifically about what I've seen change from the Obama administration to the Trump administration. So you heard me talk about the prosecution's threat to the defense about investigating things. In 2013, a member of the prosecution stood up in open court and said, essentially, defense counsel can speak to anybody about anything. So that was 2013. In 2017, the rules changed. 2017, they were told, I presume that direction came from higher, but I don't know that. But that's one change in the commission process. The other change that I've seen, just the Trump administration is spending more money on kind of the infrastructure down at Guantanamo. The Obama administration wanted to close Guantanamo. Trump administration appears to want to keep Guantanamo open. So they're just spending more money on like the physical plant, like they're building barracks for the guards and whatnot. That answer your question?
Yeah, just were the judges at all affected by the change?
The judges, I mean, no, except the judges now have to deal with the impact of the change. So Judge Pohl on the 9/11 case had to deal with this change of policy regarding what the defense can investigate. But I don't think that the individual judges are influenced by, who's the president. They're going to do what they think is right. Yes, ma'am.
There's more parking things in your class, your parking lot today, and I think your current is out. How is it that you're doing that? Do you feel any prior restraints or threatened in any way? Keeping on the way you do?
I mean, no. I mean, the short answer is no. A Marine is given a job to do, and this is my job. And my job is to, defend the rule of law and lead the military commission's defense organization. When I was a defense counsel in the Marine Corps, it was the same. I mean, the same thing. No, and the people that work for me, and I have military for all 4 branches of the service, active and reserve. I have government service employees. Nobody that works for me feels constrained in speaking out. But where we do feel constrained is the classification, the rules about what's classified and what's not classified are super fuzzy, and we feel constrained. So I feel constrained about what I can say, because if I'm going to err, I'm going to err on not saying something. So my boss, I work for the Department of Defense Deputy General Counsel for Personnel and Health Policy. They've carved out one guy to supervise me and my organization. And when first day I met with him, he said, your job is to do what you think your job is to do, without any constraint. If it's any reflection, so a year ago, I was held in contempt of court. That contempt of court conviction was overturned, but just last week they asked me to stay another year. The Department of Defense. So I feel completely unconstrained. I don't think I'll ever promote it again, but that's a different.
I guess I just want to make one quick comment. I guess it's the character of the people who do the classifications as well. I did some preliminary research on the classification system, who does it, why they do it, what is classified, what isn't classified, et cetera, et cetera. So I guess the character of the people that are doing the people's business, like you, in these military commissions is very important, and the judges, et cetera. And I don't know how they're vetted, how these folks get their jobs or whatever, but it seems to me if there's the secrecy, and you made an ironic statement about the secrecy part of it, at any rate, there's a lot of stuff in your thing to talk about, and I want to shut up now.
Okay. I do want to, I guess I do. There are equally zealous, equally honorable people on the other side. I mean, I'm not trying to suggest that the chief prosecutor and the people that work for him are doing something that they don't believe in. I just think that at this point, we each have a different worldview.
Since 9/11, there's been, I think, over 660 federal court prosecutions of people associated with terrorism.
Yes.
There's been, I think, 8, and I think there's been 8 military commission convictions. Is that
Yeah, and most of those have not survived appeal.
right? They've been overturned. I guess the question is, could those at Guantanamo right now before military commissions be tried, and I guess you would obviously fight the convictions, but could they be tried in federal courts, and what's your understanding as to why they're not being prosecuted in federal court?
So, the easy answer to your question is, could they be tried in federal court? Right now, the answer is no. And the reason why they can't be tried in federal court is because there is a statute that prohibits transferring them from Guantanamo to the United States or spending any money to transfer them. But, could they theoretically be tried in federal court? Of course. You've got, instead of my team defending them, it'd be Steve Newman's team defending them. Again, one man's view. This is definitely not the view of the Department of Defense or my organization. I mean, if they started these cases in federal court in 2011, their appeals would be done we're pretty close to being done at this point. But right now, the legislature has prohibited the executive branch from bringing them to federal court. Did I answer your question? Okay. Any other questions?
Sure.
Oh, yes, sir.
I appreciate you coming here. I look forward to your being here because I wanted to meet you. I've practiced criminal law in this country for 50 years. and the system of law that we have here, I wonder whether it is appropriate in the system of law in the Universal Code of Military Justice, whether it is appropriate to deal with these fellows that you have down there that committed the crimes that they did on 9/11. I cannot get out of my mind a plane crashing into those buildings, killing those people. I cannot get out of my mind those fellows cutting people's heads off that we've seen on television. My question is what we have, is that sufficient to stop what's going on that you're dealing with in Guantanamo Bay?
So, I mean, is the American system of justice sufficient? Yes. Is the version of the American system of justice that we're using down at Guantanamo sufficient? No. You know, and this is in where I think we're really going to see it. So right now I have a couple of capital cases going on down at Guantanamo. The big one is the 9/11 case, and the judge in that, the judge who's currently sitting on that case, he's never done a capital case. So you got the judge at the trial level has never done a capital case. The commission's cases at the trial level is being overseen right now by a judge who's never done a capital case. It's going to first be reviewed at the Commission's Court of Military Review. No judges in that case have ever done a capital case. Then it's going to go to the D.C. Circuit. I've been told that the D.C. Circuit has not done a capital case in over 40 years. So when it goes through the first level of appeal, it's going to first be judged. So these cases are nowhere near to trial. So as it goes through its first part, it goes through for its appellate review. It's going to be judged by judges who've never done capital cases. And it's not until they've exhausted those appeals that it goes in the habeas process where you're going to have judges who've even seen this. So we have so the biggest case that we've had, and the biggest case of our generation, is being, this is like the first go around. I mean, I just can't imagine what the habeas, what's going to happen on all the errors that are embedded in this. But the system of justice that's here in Ohio and the federal, my own personal view is we got a great system. I don't know why we didn't just use it. Okay.
I'm afraid we are out of time. I want to thank everyone. I want to thank the General. Please feel free to join us all at a reception afterward, where I'm sure the General will be happy to take further questions. And here is a small token of our appreciation. Thank you.
Thank you.
You'll have to take Great. Thank you so much. Great. There are a lot of really interested folks. Yeah, it's an amazing. Scary. I think people do forget what's going on or didn't know.